Good evening, everyone. My name is Patricia Aaliyah from Aaliyah Associates, condominium lawyers, and welcome to our CondoWise Learning Series, session number 14. Today, we're excited to talk about a case that recently was won by members of our team, and it's talking about when eviction is the only way out. Please use the Q&A function to submit your questions, and the CondoWise Learning session is free and open to the public. Registration is not required. So, whenever you have the opportunity, please share the invitation with your colleagues and fellow board members. Since every condominium community is unique, the advice provided in our sessions is of a general nature and is not legal advice. Recommend that you consult with a condominium corporation's lawyer. So, joining me today, and next slide, please, Justine. We have Julia White, Jonathan Wright, Megan Malloy, and Shannon Penny. And we're going to start with our pandemic update because it still is around us and we do have some new parameters around the legislation. So next slide. And Shannon, if you wouldn't mind giving us an update.
Thanks very much, Patricia. Okay, good evening, everyone. So last week, the Ontario government released a plan to safely reopen the province that will manage COVID for the long term. The plan outlines the gradual approach to lifting the remaining public health and workplace safety measures by March 2022. As of today, over 88% of the eligible population in Ontario, aged 12 and older, have received at least one dose of the vaccine, and 84% have received their second dose. So Ontario will be slowly lifting all remaining public health and workplace safety measures over the next 6 months. And this will include the provincial requirement for proof of vaccination and also wearing a face covering whilst indoor public settings. In response to the continued improvements to key indicators, the province has lifted those capacity limits in a number of settings where proof of vaccination is required, such as restaurants, bars, indoor areas of sports and recreational facilities such as gyms, and also indoor meeting and event spaces. The province also announced that they will also allow other settings to lift their capacity limits and physical distancing requirements if they choose to require proof of vaccination. This can include personal care services, indoor areas of museums and indoor areas of amusement parks, and also open house events provided by real estate agents. So locations where a wedding, funeral, or religious service or ceremony takes place may also implement the proof of vaccination requirement should they wish to do so. So the Ontario government will begin allowing large outdoor organised events, paving way for the full capacity for Remembrance Day ceremonies and also the Santa Claus parades in the coming weeks. The amendments to the regulations lift the capacity limits for all organised public events that are held outdoors, so long as the attendees wear masks when physical distancing of 2 meters cannot be kept. That means, excitingly, the ski slopes and other outdoor recreational amenities will be permitted to operate this winter without the capacity limits that we saw over winter 2020. Proof of vaccination will continue to be required in outdoor settings where capacity is over 20,000. Outdoor social gatherings will actually continue to be capped at 100 people for the time being. There's no announcement as to when that will be extended. So by March 2022, the province intends to lift all remaining public health and workplace safety measures. As I've already mentioned, this includes the wearing of face coverings whilst indoor public settings. It's also intended that the requirement for the proof of vaccination will be lifted for all the remaining settings, including meeting and event spaces, sporting events, concerts, theatres, and cinemas. On October 18th, Health Canada received a submission from Pfizer seeking authorization for the use of its COVID vaccine in children between the ages of 5 and 11 years old. There's currently no update as to when we can expect that to be approved, but Prime Minister Trudeau did announce that Children will be able to get their first doses of the Pfizer vaccine soon after the shots have been approved by Health Canada, and we're expected to receive approximately 2.9 million doses of that Pfizer vaccine after approval. Some of you may have seen today that Ontario's Education Minister announced that take-home COVID tests will be available at all public schools across the province starting in the next few weeks. So the PCR tests have been available in schools in Toronto and Ottawa and in some other communities in a similar pilot project. But now all students in public schools will have access to those tests. So if a student develops a COVID symptom or is identified as a close contact of a positive case, they can pick up a test at their school, do it at home, and then drop it off at a community location for processing. I am sure many of you are aware that the Ontario government launched the Verify Ontario smartphone app on October 15th. So to download your QR code, you can visit the provincial website. You'll now see that the link is on the screen for you, and we'll also put that in the chat. The application, it aims to make it easier, more secure, and more convenient for individuals to provide proof of vaccination where required to do so, and for businesses and organizations to verify vaccination certificates whilst protecting our privacy. So you can save the electronic version of your vaccine certificate with the QR code on your smartphone, or you can also print a paper copy. Businesses have been advised that they must accept both the electronic and paper versions. As well, while the current vaccine receipt without the QR code remains valid and will continue to be accepted by businesses, the province is encouraging everyone to download their enhanced vaccine certificate with the QR code. You will need to continue to show a identification with your name and date of birth, along with the proof of vaccination when visiting select businesses and organizations that do require the proof of vaccination. So thank you, and I'll pass you back over to Patricia.
Thanks very much, Shannon. That was a great update. It seems like things are progressing as we open up, and we're finding, I guess those circumstances where we're going to have to be able to prove that we've been vaccinated, but then we also have to manage our condos in such a way that even if you're not vaccinated, you still have some access to things. So what we're going to do is we're going to move to our poll. And as I said, we're going to be talking about compliance. And so we have two questions for you today. Has your condominium experienced compliance issues? And if we could run that poll first. And the second one is embedded in that poll, which is, if so, how did the issue get resolved? And so if we could have our participants vote on that. We can close that poll. What are our results there? Oh, okay. So nobody actually participated in the poll. So I don't really have an answer for you, but I can tell you that compliance is really alive and well and as an issue for condos. And as you know, we have a long history of that. And with that, now with the CAT expanding its jurisdiction, we really have to think about where compliance is going to end up. But tonight, what we're going to be talking about, and if we could have the next slide, please. We're going to talk about a case that we had been working on, and Julia was one of the lawyers instrumental in this matter, and she's going to explain to us how this compliance file worked. So Julia, why don't you explain to us a little bit about the context and take us through that?
Thanks, Patricia. So first, we're just going to talk about all the parties that were involved. So first, we have the condo corporation and the owners, residents, staff, and agents who were no longer able to enjoy their units or were subject to various forms of abuse by the occupants of one specific unit. As you know, condos have both the right and the obligation pursuant to Section 17 and 119 of the Act to take all reasonable steps to ensure that all owners and occupants comply with the Act and the condominium's governing documents. So second, we have the owner of the unit. In this case, the owner was not a resident or occupant of the unit and were not the cause of any bad behavior, but they were nonetheless responsible for the behavior of their occupants. So under Section 119 of the Act, a unit owner has a statutory obligation to comply with the Act and the corporation's governing documents, and also to ensure that their occupants comply with the same. So the legal relationship is between the condo and the unit owner, and the owners are ultimately responsible for the actions of their residents and tenants. So next we have the occupants of the unit who were residents, but in this case were not tenants. There was no lease agreement between the parties, which would have created a tenancy relationship. If there is a lease, a copy of the lease is required to be provided to the condominium under the Act. Residents, whether they're tenants or just occupants, are still required to comply with the Act and the governing documents, again, pursuant to Section 119 of the Act. In this case, the occupants committed multiple serious breaches of the Act and the governing documents, as well as the Occupational Health and Safety Act and the Libel and Slander Act, which necessitated enforcement by the condo and involvement by our office. Also, just as an aside, if you are a landlord in a condominium, you should be delivering a copy of the corporation's governing documents to your tenant so that they are aware of both their rights and responsibilities with respect to living in a condo. And Megan and John will talk a bit later about the importance of the distinction between a tenant and a resident and the considerations for each when looking at eviction. So lastly, we have the lawyers, our office. If we're involved, it's not usually a good sign, and there are generally cost consequences associated with our involvement. So next slide, please. Okay, so just a little background. As Patricia mentioned, today we're doing a specific case study on one of our own condominium clients who we helped manage and eventually remove 2 occupants who were causing a host of issues, both in their unit and on the common elements. It started with a simple issue. The occupants of the unit were seen on the common elements during the height of the pandemic last summer, not wearing their masks and not practicing social distancing. So the corporation sent a notice to a number of residents who were seen on the common elements without masks, just advising them of the requirement to wear a mask or face covering. However, when these particular occupants received the notice, they saw it as more of a targeted attack directly against them, and they alleged that they were victims of racial discrimination. This is when the behavior of the occupants began to escalate, and complaints started to flow in from multiple owners, residents, agents, and staff at the corporation. Most of the complaints related to concerns regarding health, safety, and quiet enjoyment of the property, which stemmed from the ongoing disruptive, dangerous, harassing, and threatening behavior of the occupants. Next slide, please. So the conduct at issue. You'll see as you read through this slide, if you can read it, that there was harassing, defamatory, abusive, inappropriate, and threatening behavior that other residents, guests, board members, property management, security staff, and also members of our office were subject to over a period of approximately 1 year. The behavior occurred within the unit and on the common elements and was both in person and through email. The occupants' behavior also necessitated the attendance of police at the property on several occasions. So while residents have rights under the Act that they can exercise to communicate concerns that they may have regarding the operation and management of the corporation, this has to be done in a respectful and courteous manner. There is a limit to the method and type of conduct that a resident can engage in. So some of the conduct on this slide might not seem so bad, but when you really get into it, looking at the death threats, racial slurs, homophobic comments, these are more concerning, and they happened over and over again, increasing in seriousness as the time went on. There didn't appear to be any real attempts by the occupants to live within a condominium community and to respect the rights and obligations of those who also live and work in that community. So each of these complaints on their own would be the basis for a compliance letter But the continued repetitive and escalating nature of the breaches, particularly the repeated death threats to the corporation staff and volunteers, and even to police officers who attended at the unit, were especially concerning. Next slide, please. So the steps taken by the corporation to address this conduct. The steps taken by the corporation included various telephone calls, emails, and letters written by property management to the occupants, in-person discussions. There was an offer to meet with the occupants, and there was involvement of our office. So when we became involved, the corporation had an overwhelming number of complaints from residents, staff, and agents of the corporation. Our first step was to review the information and documentation provided. And based on our review, we wrote a compliance letter to the owner and the occupants of the unit. Prior to this, the occupants had been residents of the corporation for many years, and until recently had not caused any trouble or raised any concerns regarding management or operations of the corporation. So we confirmed, based on the correspondence, security reports, and the audio and video footage, that the behavior of the occupants met the standard of both workplace harassment and defamation under the Occupational Health and Safety Act, the Libel and Slander Act, and was a danger to both persons and property under Section 117 of the Act. So interestingly, when we searched title to the unit, we noticed that the occupants of the unit were not the legal owners, even though they had been representing themselves as such. At that time, we had no address for service or any other contact information for the legal owner of the unit. So the only way for us to contact them was by sending the letter to the address on file, which was that of the unit. So after the first compliance letter, not only did the behavior of the occupants not stop, it actually began to escalate. We had some initial suspicions that there could be some mental health issues at play, and therefore needed to be cautious and respectful of that. So we tried to open the lines of communication between the parties. We offered an opportunity for the occupants and the unit owner to speak with council, management, as well as the board, to discuss any issues that they had and any possible solutions. The corporation also tried to give the occupants the benefit of the doubt and explain the inappropriate behavior, the various allegations in their letters, and just generally explain their side of the story in case there was a bias or we were missing some factual information. We were not engaged in our offers to meet. So following this, there was a resurgence of inappropriate behavior. We sent another compliance letter to the owner and the occupants, again outlining all of the inappropriate behavior and the breaches of the Act and the governing documents, but also confirming the corporation's desire to resolve the issue amicably and without any further legal action. So the following month, the unit fell into arrears and we proceeded to register a lien. It was at this point that we were contacted by one of the mortgagees of the unit. And after some back and forth and a little bit of digging, we were able to get in touch with the owner of the unit, who we found out to be the mother and grandmother of the occupants. She said she had no prior knowledge of the issues and that had been going on over the last couple of months. So the lien was discharged, but the occupants' behavior didn't stop. So we again sent another letter, this time to the occupants and to the owner, now that we had verified her identity and were actually able to contact her directly. We wanted all breaches and inappropriate behavior to be documented and brought to the attention of all of the parties. Due to the threats for safety and security of other residents, as well as the corporation staff and agents, we advised that the police be contacted for all future incidents of harassment, violence, or nuisance. Following this, we had a conversation with the owner and their representative at the time, who was their mortgage broker, and further conversations later with their counsel. The owner was very emotional and seemed overwhelmed by the issues being presented and what was required of her. She requested time to speak with the occupants and try to resolve the issue on her own. The corporation was empathetic to the owner and to the occupants and understood the toll that the pandemic was taking on people and their mental health. So the board granted the indulgence and recommended that the unit owner find a way to remove the occupants from the unit on her own. The best case scenario here for the corporation and for the unit owner was for an amicable resolution to be reached and for the occupants to be peacefully removed from the unit. So time was passing and the threats of safety and security were increasing, disturbances to other residents were increasing, and the occupants were not willing or not able to discuss and resolve the issues with the corporation. The owner was not responsive enough. Staff and agents of the corporation were continually targeted and harassed and no longer felt safe in their work environment. Other residents were still being harassed and no longer felt safe in their homes, especially those living on the same floor as the occupants. So ultimately, the corporation tried to be patient, but the owner wasn't able to effect a timely and effective solution, and the behavior of the residents continued to worsen. At this point, we advised the corporation that the only option left was litigation to force the removal of the occupants from the unit. And that takes us to the next slide.
I'm just going to jump in here for 1 second and talk about Section 119, because Section 119 of the Act actually talks about the expectation of compliance and that everybody is expected to comply and that the corporation will be the entity that is expected to do the enforcement. And yesterday I had the opportunity of speaking at the Eastern Ontario AGM on the legal panel, and it was interesting, when I reflected on it, that the condos are the fourth level of government. And so we need to make sure that they have all the right tools to affect compliance so that the society that the condominium represents actually is maintained within the parameters set by the Act and the DEC and the bylaws and the rules. So now I'm going to turn it back over to Julia to talk a little bit about what happens when those compliance letters don't work.
Thanks, Patricia. So we've separated this into 3 different sections here. So I'm going to talk about the CAT, so the Condominium Authority Tribunal, and whether the CAT has jurisdiction. So the general answer here is that it depends on the issue. Currently, the CAT has jurisdiction with respect to some records disputes, disputes regarding pets, parking, vehicle storage, and then indemnification related to any of those disputes. But the CAT regulation specifically states that the CAT does not have jurisdiction over the issues just discussed, where there's also a dispute with respect to Section 117 of the Act, a Section 98 agreement, or an EV charging agreement. So the CAT will be expanding its jurisdiction again in January 2022 in conjunction with amendments to Section 117 of the Act to include nuisance-related disputes. But we're going to be talking about this a little bit later on. So at this time, the CAT's jurisdiction, related to this case study, at the time of the case study, the CAT's jurisdiction had not yet expanded to include these nuisance-related disputes. However, even if it had, the behavior here was so egregious that it wasn't just a nuisance, but it actually created a danger to persons and property, which is a violation of Section 117 of the Act. And because of the violation of Section 117, the issue was not within the CAT's jurisdiction. So Patricia, I'm going to pass it back over to you to introduce the next question.
Okay, so in terms of Section 132 and arbitration, are we going to have Megan? Are you going to be chatting a little bit about that?
Yep, that's right. Okay, so thanks, Patricia. So Section 132(4) of the Condominium Act provides that every declaration is deemed to contain a provision that the corporation and the owners agree to submit a disagreement with respect to the corporation's declaration, bylaws, or rules to mediation and arbitration. So basically, this is interpreted as mediation and or arbitration being mandatory before going to court where there is a disagreement between a corporation and an owner with respect to that condo's governing documents. However, case law has affirmed that mandatory mediation and arbitration provisions in Section 132 of the Act do not apply to disputes regarding breaches of the Act itself. The court has also held that Section 132 of the Act does not apply in circumstances in which the evidence establishes a clear violation of the Act, the declaration, and the rules. So where a corporation primarily claims relief on the basis of an owner's breach of Section 117 of the Condo Act, it is our position that we are entitled to bring an application directly to court without first proceeding to mediation or arbitration. And the reason for this is because Section 117 of the Act prohibits conditions that are likely to cause damage to property or injury to an individual. So when there has been a breach of this provision, it's usually urgent or serious enough to warrant immediate court intervention. We have experienced some recent issues when trying to schedule application dates where the court has questioned whether mediation or arbitration was necessary before coming to court, even though those case law precedents exist. So essentially, the court has been hesitant to schedule applications without first having the file vetted by a triage judge to hear submissions on why mediation is not required. So there does seem to be some desire for condominiums to try and have less serious matters resolved outside of the court, and where appropriate, mediation or arbitration may be the most efficient and least costly way to resolve a dispute where there is no urgent compliance matter or dangerous condition involved. So then when we are proceeding to court, John's going to talk us through the steps in an application.
Thank you, Megan. And we look at Section 134 of the Condominium Act. It's really one of the sharpest tools in a litigator's toolkit when seeking to bring about compliance for a unit owner that's not overly compelled to do so on their own. Section 134 gives the court the ability to sort of craft an order in any terms necessary to bring about compliance. And we heard Megan talk about how the court, sort of presently at least anyway, is somewhat hesitant to schedule applications under Section 134 because of the provisions of Section 132 that require some disputes to be mediated and arbitrated. And really, in our experiences, it's because the court is a bit backlogged for numerous reasons. An overburdened courthouses across the province, coupled with the pandemic, leads the court to try and say, let's get all these things off our plate. Let's push them out of the courthouse for other matters because they can be dealt with potentially more effectively or more quickly outside of the courtroom. But Section 134, giving the court the right to craft the order necessary to bring about compliance, also gives the court the ability, very importantly, to fully indemnify condominium corporations for any costs that they incur in seeking compliance or obtaining a compliance order. And those costs themselves, if you spend $20,000 through the litigation process from the issuing of the notice of application right through to obtaining your judgment, those costs are captured under Section 134 sub 5, but also other costs that have been incurred leading up to that. If you were to divide the people on this sort of panel into two, we would have Patricia and Julia from our office, our corporate litigator, or sorry, our corporate lawyers who in this particular file had sort of set the background, set everything up, done a lot of the groundwork, papered the file, and then handed the file off at a point to Megan and myself to take the matter before a judge. Typically, when the matter is handed off from a corporate lawyer to a litigator outside of a condo context, that is when the court will consider court fees to be or legal fees to be captured under the Courts of Justice Act and the legislation that deals with those. But under Section 134.5, we would also get the before cost captured, which is a hugely important part of the legislation. So Section 134 not only gives the court the ability to craft the order, but also to fully reimburse or indemnify the condominium corporation for any of its costs.
And I also think, John, that makes a lot of sense, given how the courts in the past have also said to us, write the letters, give them notice, make sure that we give every opportunity to try and correct the behavior before you escalate to something like a court application. So it does make sense, I think, in this particular context, especially if, 134.5 is about making sure that the party who's the offending party picks up the cost of these kind of applications after compliance has been repetitively asked for. Because I think the legislation confirms, and this is Skyline and MTCC 1385, that really it's about, not penalizing your neighbor, right, for your bad actions, as it were.
There is an unwritten, well, it's certainly been written now by the judges, but throughout the Condo Act, there's no requirement to act reasonably to get your costs. But the courts have certainly written that into their judgments whenever we look at the reported decisions, and some condos are saying, well, I need compliance, but it's maybe not such a serious matter, but they've run to the judge and said, we need a $30,000 cost award as well as this compliance order, and the judges are sort of starting to look at this now and saying, well, you didn't act reasonably. You can have your compliance order, but I'm not going to give you all your costs because you saw the court as the appropriate place to bring this in the first instance. So there is that background that that Julia talked about, the letter writing, the papering, building the evidentiary record is a key part of section 134.5. Running to a judge because somebody is banging on a wall on one occasion and saying, I need a compliance order, you need to order that they stop it. Well, one, it might not get you the compliance order because it's a one-off occurrence, but two, a judge is not going to give you 20 grand for the cost of bringing that application before the court when the condo didn't try and resolve it in the first instance by itself.
Right. So there's a tipping point where it makes sense to go to court, and there's a point where you still have to try your own methods.
Yeah, I would agree with that. I think we're on to the next slide there.
Yeah.
So we're now into the steps in an application, and hopefully nobody's had to go through this either personally or as a board member. But the first thing when we're asked to bring an application and we've done the background work, the file's been papered, and we have the instructions to seek a compliance order from a judge, is to draft what is called a notice of application. It's really the first document that should be filed with a court. It sets out the relief that the applicant or the condominium corporation in this particular case is looking for. It doesn't contain evidence. It doesn't contain long flowing paragraphs about what's happened or really in any way a narrative. It's really what the relief you're looking for. So what do you want the court to give you? In this particular case, we wanted the court to order first and foremost that the occupants of the unit stop conducting themselves in the manner which they had done for the previous year. So we stopped the homophobic slurs, we stopped the allegations of racism, we stopped the harassment, we stopped the death threats, hanging out the windows and abusing board members. That has to stop. General compliance with the Condo Act, the rules, declaration, and bylaws. But also in this case, which is a little more unusual and certainly isn't often requested and even less often granted by the court, was an order that the unit owners, the occupants of the unit be prohibited from residing in the unit. And then secondly to that, if the court was prepared to grant that relief, that then the sheriff be permitted or that we be permitted to engage a sheriff if the occupants refuse to leave. So we have what we want set out in the first few paragraphs of the notice of application. And then following the request, we go into generally why we need that order. Very, very briefly and succinctly. Again, it's not explaining everything that's happened, but very briefly a background and very briefly why the order is necessary. So highlighting some of the conduct, outlining the condominium's obligations to both the other unit owners and the staff and employees of the condominium corporation under the Occupational Health and Safety Act, and then the various rules of court that we rely on. So we put it all before the court, the first document that we have, and hopefully the first document the judge reads and sets out really what we're here for or what we're there for. So once a notice of application is filed, we will serve that on everybody who's a party to the application. So in this particular instance, it was the unit owners and the occupants of the unit. After we deal with the notice of application, either concurrently with service or shortly thereafter, we would prepare the evidence, and Megan is going to touch on the evidence and how it's compiled.
Okay, thanks, John. So the evidence in an application is filed in affidavit form. So unlike a trial or what you'd usually see on TV where there's live witnesses answering questions, in these circumstances, it's usually just the lawyers for each party and the judge. So in order to do this, we ask for a representative from the corporation with knowledge of the matter and history of the issues to agree to act as the corporation's affiant. Usually this is property management or a member of the Condo's current board of directors with knowledge of the issues. So this individual is asked to swear an affidavit detailing the entire history of the matter and attaching all evidence compiled by the corporation as exhibits. And the affidavit is usually drafted by our office with input from the affiant. And then once it's finalized and sworn, the affidavit gets filed with the court. In the case that we've been talking about today, we did have a bit of trouble finding someone willing to act as the corporation's affiant due to fear of repercussions or being targeted by the respondents. Because at the end of the day, we do have to keep in mind that these individuals all continue to share the same condominium space until the application is addressed by the court, and will possibly have interactions during that time. But we did eventually get one of the board members to step forward to act as affiant in those circumstances, and that is what was ultimately filed with the court to support the corporation's position. And then once the affidavits are filed, we move on sometimes to cross-examinations, and John's going to talk a little bit about that.
Thank you, Megan. So when we look at, or when we talk about cross-examinations, I'm sure most people here have seen some type of TV show or movie where there's somebody in a witness box being questioned by a lawyer, maybe sometimes right in their face, or pacing up and down the courtroom, peppering questions with a witness. It's not quite as dramatic as that in a typical application. Normally, in the before times, as we're coming to know them, all the parties would be sat in a court reporter's office, facing each other across a table, whether it be a court reporter at the top of the table, plaintiff for the applicants on one side and the respondents on the other side, and the lawyers would take turns asking the affidavit, the person that swore the affidavit evidence, the affidavit evidence questions on their affidavit evidence. Generally, as long as everyone is being forthright and truthful through their evidence in their affidavit, no issues with respect to the cross-examinations. It's usually a fairly benign process, but on some occasions there are inconsistencies that come out, or there is pretty large inconsistencies. People change their minds. They say things like, well, my lawyer drafted this. I didn't really know what they were saying. I just signed it because it was put in front of me. I didn't mean what I said. You're twisting that. That's not what that says, despite it being written on the page in front of them. But that doesn't always happen. The whole purpose of the cross-examination is really to test the evidence. And if you're being cross-examined, or if you're ever cross-examined, it's undoubtedly an uncomfortable experience. It's an uncomfortable experience for everybody in the room. But you're not there to help your own case. You're really there to do a job to neutralize the evidence, and the other lawyer will try and bring out holes in your case. The entire product of the cross-examination is then compiled into a transcript, and the transcript is often handed up to a judge, and the parties, their lawyers, will make reference to the cross-examination transcript throughout the hearing. In this case, because the respondents chose not to participate in the proceeding and chose not to file evidence, there was no need for cross-examination. But many other cases there are, nearly all cases that I come across, there's a need for cross-examination. And throughout the cross-examination, the lawyers have specific questions or specific admissions that they want to get, with a mind to then building a factum, which Megan will talk about in a few seconds. And the factum, whenever it goes before a judge, highlights not only the law, but the inconsistencies in the evidence. And Megan is going to talk a bit more about the factum.
Okay, thanks, John. So a factum is a written argument that is filed with the court and provided to the judge before they listen to the lawyers argue the case. A factum generally contains a summary of the facts of the case, details the issues for the consideration of the court, and then takes the court through the legal authorities and argument the corporation is relying on in support of its position. Usually, the judge will read all of the factums filed by the parties and read the cases or legislation referenced in each factum so that they are familiar with the case and the issues before we go to court. And we usually hope that will be the case, but sometimes a judge will not have the factum. Sometimes there's filing issues, or they just are too busy to get to it before the court hearing. So this means we have to take a little bit more time to walk them through basically each step of the case, which we will do by relying on the factum. So at the oral hearing, the factum is a guide for the judge and the lawyers to follow, and is the basis for the arguments made in court. So generally, preparation of the factum is the most comprehensive part of the litigation process. And it's important that we spend a lot of time drafting the factum and considering the legal arguments that go into the factum, because the court will usually also rely heavily on the content of the factum when making its decision. Oftentimes, judges will listen to the oral argument and then say, okay, thank you, I'm reserving my decision, and then take the factums. And sometimes it can take 1 month up to 6 or 7 or 8 months to get a decision. So by that time, they'll have forgotten what we told them in court, and they will go back to the factum to refresh their memories on the facts of the case. I've also been in situations where we get to the court expecting to, go through a full day or a half day hearing, and the judge says to the lawyers at the beginning of the day, thank you, counsel, I've read your factums. I don't need to hear anything from you, sorry. So in those circumstances, we don't get to say anything. So you better be sure what's in your factum you're happy with, because you might not be given the opportunity to speak. You never really know what's going to happen when you go to court. So it's important that we make sure everything we want to convey is in the factum before it gets filed. And then just coming back to the case we're talking about today, the issues before the court in that case were presented in the factum as follows. Number 1 was whether the condo had the ability to enforce the act and its own governing documents against the respondents. Number 2 was whether the conduct of the respondents constituted a breach of the act and or that condo's governing documents. Issue 3 was, if so, if a breach was found, whether the condo was entitled to the order sought. And then 4 was whether the respondents were responsible for the condo's cost of the application. And then John's going to get back to the actual hearing of the application.
Thank you, Megan. Can we go on to the next slide as well, please? So when we have everything prepared and we file everything with the court and we serve everything on the other parties, and in this case, there was no responding or reply material necessary because the respondents chose not to respond. We take everything in before the judge. And in this particular case, the judge had read the evidence. She had read the affidavit evidence and had been through it. There's always a bit of uncertainty when you walk into a courtroom. Most judges have a full plate, either reviewing material for the next day or sometimes the current day if they're working into the wee hours of the morning, as they say, but also a list of decisions that are probably under reserve that they have to spend their time writing. And in this case, we had asked for an urgent date because of the escalating conduct of the occupants of the unit. We were given an urgent date, which usually means the judge won't have had time to review everything. So we have to plan our submissions in a sort of linear way, taking a judge through everything from, how the condominium is structured, what the condominium is, the provisions of the act we're relying on, why we're here, what we're asking for, and then going into judicial precedents that have been previously set, and sort of trying to convince a judge that you have the ability to give what we want here, and this is everything that you need to know about this particular case. But when Megan and I appeared in the courtroom a month ago on this particular case, the judge had, she said right at the outset, I don't need to hear anything on the evidence side. I'm convinced that the conduct is very egregious. I am concerned about my authority to order what you're asking. The judge may not have had a lot of exposure to the Condominium Act. So we started off by taking her through to section 134 of the Condo Act and saying, look, this is the authority. This is why you can give me what I'm asking for. You have the ability to craft the order necessary to bring about compliance. Now, the fact that the respondents chose not to participate was somewhat of a blessing, but also made it a little more difficult given the relief that we're asking for. You walk into the courtroom and you're saying to the judge, I want you to evict these people. They're not here. They haven't had their say, although they had their opportunity to. And I want you to kick them out of their home. But we'll tell them about it. Don't worry. Well, just you sign this piece of paper, please, and I'll send it to them. Don't worry, they'll understand what it's about. They've read all the material, I think, and they're aware that we're here today. So the judge was very concerned that, one, we were asking for this particular order, but also there was an issue with respect to the interest the occupants had in the unit. So we've talked about how they were occupants, but there's a specific section of section 134 sub 4 that speaks to the court's restriction on a particular type of order that they can give. And that order speaks to, or this section speaks to the fact that a court can't terminate a tenancy if there hasn't been a prior breach of a compliance order. In this particular case, certainly the starting position would be that, well, they're not the unit owners, so they're probably tenants. But after Patricia and Julia had done the groundwork on this and had discovered that they actually weren't tenants, through some letter writing with the unit owner's lawyer, who was appointed for a very short time as their lawyer. And he wrote a very helpful letter to Patricia and Julia explaining, well, you know, these aren't tenants. They're my daughter and granddaughter. They're actually what would be called the beneficial owners of the property. And that letter was possibly one of the most helpful things that we had in our evidence. That took us out of having to convince the judge that they weren't tenants and just saying, well, like even the unit owner, the owner says they're not actually tenants. They're also they also have some type of ownership interest in the unit. So after speaking to the facts of the case and why the condo could obtain the order it requested and why the court had the authority to make that particular order, and taking the judge through the fact that these aren't tenants, as you would find described under section 134 sub 4, they're actually owners in some respect, and they're holding themselves out as the unit owners holding themselves out as owners, you can grant this order. And the court was satisfied with that. Having said that, there may be a presumption that occupants of units are tenants. If we didn't have that letter, it may have been a little trickier to convince the judge. However, the court did look at Section 83 of the Condo Act, which requires a unit owner, when the unit is leased, to provide a copy of the lease to the corporation, and the corporation would then hold that as part of its records. And the court commented on the fact that the condominium's evidence stated that there was no lease provided as required under Section 83. So if this situation ever come up again, I think I would be comfortable going into a courtroom if we had no lease and saying to the judge, well, there may be a presumption that there's a leasehold interest or a tenancy in place here, but there's also no leases required under Section 83 of the Act. And that's not the condominium corporation's obligation to obtain. That's the unit owner's obligation to provide us with a copy of the lease. Section 134, though, may be troubling when you have actual tenants in a unit that are causing some trouble and you want to evict them. Patricia, do you have any thoughts on why Section 134 exists and why you could evict an owner on the first instance, but not a tenant?
Oh, well, I think it's because I think there's a bias, and rightly so, that people should actually, first of all, I think the fact that you have to get an order under 134.3 and show that there's a breach of the order because of related to non-compliance, then gives you the grounding to force somebody to terminate their tenancy. But I think it's security of their tenancy. I think that's a principle in Ontario law. I think that's a real, inherent bias that we have, that people should be protected in their homes. And, for tenants, it's different. They don't have an equity stake. Where do they go? They're not selling something that they could potentially take the money and go somewhere else. These are tenants, right? So I think it's that, and it's also, the right that they derive is from a unit owner. There's also a contract somewhere along the line here that has other terms that are involved. So I think it takes more than just a allegation that they're bad tenants, right? That's what we're looking for.
I think we can go to the next slide.
Okay, thanks. I think this is me, the aftermath. So although I mentioned that it can sometimes take months before we receive a court's decision, as John noted, we did bring this application on an urgent basis. So we received the court's reasons for decision and order fairly quickly. I think actually in under less than a week, which was very helpful given the conduct that the corporation was faced with, and that was at issue. So just to go through the reasons for decision in summary, in reaching its decision, the court went through the evidence that was presented and ultimately found that it was clear that the occupant's behavior was escalating to the detriment of the condominium community. The court also found that any reasonable person would find the content of the communications sent by the occupants to the corporation, its staff and agents vexatious and upsetting to hear or read, and to cause concern for their personal safety. The court then went on to consider the legal authorities and confirmed that the corporation had met its onus of establishing that the respondents were in violation of the Act and its governing documents. The court confirmed that the corporation was justified in seeking an order that the occupants cease and desist from their uncivil, disruptive, and illegal conduct, and concluded that this was not a case in which the court should afford the occupants further time to show a change in their conduct. So we didn't need to come back. She found that it was serious enough that she could address it during this application. And the judge then went on to order various relief in the corporation's favor, including an order that the occupants were to vacate the unit within 30 days of her order, failing which, if they didn't leave, our office could engage the sheriff to remove them. The corporation was also awarded its full costs for the application, which were in the region of $20,000 and which the judge found to be reasonable. The corporation was also permitted to charge those costs, as well as the additional legal costs it had incurred in its attempts to secure the respondent's compliance in the year prior to the litigation back to the unit under Section 134(5) of the Condominium Act. And so in this case, the condo did receive full indemnification and in the end will not have had to spend any money to effect compliance, which is a great thing. And I think we touched on this, but this is important because, you know, it's been recognized that the innocent owners who do comply and have had no involvement in the matter shouldn't have to suffer the cost consequences of another owner's breach. So in the end, you know, positive outcome for the corporation. And I think that takes us to the next slide.
Yeah, and in this particular case, one of the things that the court gave the condo the ability to do would be to come back and seek a forced sale of the unit if the conduct that was complained of was to continue post-service of the order. In this case, is still fairly young, so you know the matter hasn't been brought back before the court. But there are cases in which the conduct of certain unit owners, these cases are sort of famous in the condo industry now, have allowed the court to have the discretion and the authority to just say to unit owners, you've got 3 months from the date of this order to sell your unit. Your conduct is extremely reprehensible and it can't continue. When we see these court decisions, words like draconian and extraordinary relief are used throughout the decision, and they're only ever, that type of relief is only ever ordered whenever it's clear to everybody, and you know, mostly the judge, that this person or these people aren't capable of being governed by the rules of the condominium community. The most famous sort of case that we've seen out there is MTCC 747 in Coralec. And in that particular case, the court found that the respondent unit owner had repeatedly engaged in extreme behavior, including physical violence. She had used a Rottweiler, a large aggressive dog, to frighten and intimidate other unit owners and residents, had some colorful language and verbal abuse sort of lobbied at other residents and interfered with the enjoyment of the property and caused actual damage to the property. And it was clear to the court that this behavior was a contravention of Section 117 of the Act. In looking at that particular court decision, the court had said that, in short, this case is a perfect storm where the misconduct is serious and persistent, where its impact on a small community has been exceptional and where the respondent appears to be incorrigible or unmanageable. In all these circumstances, it would be unwise to try to reintegrate Ms. Coralec into a community that fears her and that she has persistently tried to intimidate. The result for Ms. Coralec was she was given 3 months to sell her unit, to list and sell the unit. And the court ordered that the dog that was being used in part to terrorize the community, the Rottweiler, to be removed from the unit within 10 days of that particular order. Megan has also been involved in a case, and she's going to talk briefly about it, PCC 304 and Hersey, which resulted in the sale of a unit.
Right. So Hersey was actually an application brought by our office several years ago now, seeking an order to force a unit owner to vacate and sell her unit as a result of violent conduct, the abuse of alcohol and drugs on the corporation's common elements, and disturbing the use and quiet enjoyment of property for the other residents. Brief summary, the conduct at issue began in July 2013 when various owners began complaining about the owner and her guests disrupting private functions in the party room, playing loud music at all hours of the night, and consuming alcohol or drugs on the common elements. This was mostly a senior community, so the conduct of the owner, but mostly of the guests she was inviting to her unit, was seriously impacting the community. Multiple compliance letters were issued by our office and property management, but the conduct didn't stop and in fact escalated. Over the next 3 months, the police attended at the corporation on 6 different occasions to address the unit owner and her guests' disturbing behavior. Circumstances further escalated dramatically in the last week of November when a double stabbing occurred on the condo's common elements, which resulted in 2 individuals being taken to the hospital and various guests of the unit owner being taken into police custody. Just over 2.5 weeks later, another incident occurred where a SWAT team was required to attend at the condo in response to a shooting that actually happened right in the unit. So not a great situation for the older community at that condo. So obviously, as a result, the condo had no other alternative but to expedite an application with the court with the view of compelling the owner to leave the community. Ultimately, when we did get before the court, and the decision rendered is not very long, but the court indicated that it was satisfied that given the outrageous and persistent conduct of the unit owner, including incidents of stabbing and shooting and other intolerable conduct, a perfect storm existed where the misconduct was serious and persistent with exceptional impact on a building occupied by law-abiding senior citizens, and that the respondent on the evidence was incorrigible and unmanageable. And of note, again, this was a case where the unit owner failed to respond to any communications by the condo or the lawyers and didn't respond to the application or attend court on the date of the hearing. And so in those circumstances, the court found that it was fair and equitable to have the respondent ordered to sell her unit.
Wow.
And I think
that
that's
was pretty overwhelming case.
yeah.
But I have a question for you, John and Megan. Maybe you can give us some insight where you suspect mental health issues are part of what's going on. I think we have more awareness around mental health these days, and we know that, it is something that we need to be aware of and recognize its impact. So what are your thoughts as litigators on dealing with suspected, not necessarily clear mental health issues?
I think
Right,
if you want to go first,
go ahead.
Megan, then I'll go.
No, you go ahead.
Okay. In terms of the case that we had just dealt with, the one that sort of sparked this presentation, in paragraph 24 of the decision, the judge writes, the evidence is clear that the occupant's behavior is escalating. If the unit owner's view is accurate that the occupants required mental health treatment, and that was based on the letter that the unit owner's lawyer had written to Patricia saying that there was likely mental health issues. So if the unit owner's view is accurate that the occupants require mental health treatment, then they appear to be decompensating over the last year to the detriment of the community in which they reside. So in this particular case, the judge appears to have at least considered that there had been mental health issues. The judge had the option, as any judge does in hearing these matters, to, on their own authority, without having the request being made by any party, order a capacity assessment be done under the Substitute Decisions Act. And that's something that we didn't ask for, knowing that the court had the ability to make that order. And certainly we had prepared to make submissions to the court on that particular issue. If the court had said, Mr. Wright and Ms. Malloy, I see all the issues here, and I agree it's serious, but I am more than concerned about the occupant's mental health. I think there may be something here. I'm concerned that they don't understand what they're doing. The court can have that capacity assessment done, and to that extent, that I think, Megan, you were involved in a case where there was capacity assessments discussed at length. Is that correct?
Very at length, yes. So yeah, I think getting back to Patricia's question first, I think it certainly varies on a case-by-case basis, depending on the circumstances that you're dealing with, as well as who is pushing the litigation forward. So as John said, in this case, we were the ones pushing the litigation forward. We weren't too concerned with any prolonged consequences or the mental health issues going forward, because we were simply seeking that the occupants be removed from the unit, which would kind of solve the issues for the corporation, and that was the end of that. In the case that John just brought up that we were involved with, actually it was many different cases brought against a corporation, a client of ours, by the same unit owner. In that case, because of the content of those applications to the court and the conduct of the unit owner, We showed up in court one day and a representative of the public guardian and trustee was there who had been invited by the court. And kind of on the fly at that hearing, we did make an application to the court to have a capacity order made to assess the capacity of that individual to carry on with litigation without assistance. And the judge did see fit to make that order. So I think it'll depend on the circumstances, but in this case, the corporation was subject to all of this litigation by the same person, and there was really going to be no way out. So that did assist ultimately in that case. And again, where there is someone who appears to have perhaps mental health issues or difficulty maybe comprehending, what's going on, obviously, litigation is quite complex for a layperson who may be self-represented. So sometimes there is an opportunity for us to get the public guardian involved where the person doesn't seem to have anyone else to go to for assistance. So that's another option as well.
Great. Thanks, guys. So moving right along, Julia, you're going to talk about upcoming jurisdictional issues.
Yeah, I'm just going to give a brief overview. So as I mentioned earlier, as of January 1st, 2022, the CAT will be expanding its jurisdiction to include nuisance-related disputes to align with the changes that are coming into effect also in January 2022 to Section 117 of the Act. So the new Section 117 will still prohibit any activity or condition that is likely to damage property or cause injury to an individual, but will also prohibit any activity that results in the creation or continuance of any unreasonable noise, odor, smoke, vapor, light, or vibration that is a nuisance, annoyance, or disruption to an individual in a unit, the common elements, or to the corporation's assets. So as of January 2022, the CAT will have jurisdiction to hear disputes related to nuisances, annoyances, or disruptions under subsection 117.2 of the Act, so related to noise, odor, smoke, vapor, light, and vibration. The CAT's jurisdiction on these additional matters will not apply where the dispute also relates to dangerous conditions under section 117.1 of the Act, the new section 117.1 of the Act, which is activities or conditions likely to damage property or cause injury or illness to an individual. So this expansion is sure to have an impact in the industry in terms of enforcement and governance within condominiums, and it'll be interesting to see how it plays out in practice.
Great. Thanks, Julia, for clarifying, and that will be interesting to see where we go with that in the January of the upcoming year. So if we have any questions, please type them into the Q&A or raise your hand. And we will take those. But in the interim, what I'd like to do is if we could go to the next slide and just highlight for you some of the upcoming CCI events. Eastern Ontario, which John is a big active member of, they have a virtual directors course coming in on November 3rd. Grand River, Level 300, Community and Compliance. Conference and Trade Show. The CCI National Conference is coming on November 13th. That's going to be great. You're going to have an opportunity to go across the country and hear from all the different chapters. And then the Golden Horseshoe is having a discussion on Level 300, the CAT, and that will be definitely covering the new expansion of the CAT in January. Huronia, we also have a Lunch and Learn webinar coming up, and we have them in both November and December. December is a legal panel, and we hope to see you at all of these events. So thank you so much for being with us. We appreciate it. Guys, thanks for winning that case. That took a lot of work. Appreciate your advocacy skills tremendously, all the prep and the work, and it worked out for the condo tremendously well that they didn't have to pay all of those costs. So good night, everybody. Thanks again, and we'll talk to you soon.
Thank you.